SJC-12203. Richard Crowell v. Massachusetts Parole Board.
Ms. Cohen, good morning.
Mr. Chief Justice, and may it please the court. My name is Tabitha Cohen, and I am a second-year student at Harvard Law School, certified to argue before this court under Rule 303 of this court. I, along with my supervising attorney at the Harvard Prison Legal Assistance Project, John Fitzpatrick, will be representing the plaintiff, Mr. Richard Crowell, in today's proceeding. By leave of this court, the arguments will be bifurcated, and I will be handling the first two issues of the case, the Standing Order 1-96 issue and the ADA issue, and Mr. Fitzpatrick will be arguing the third and final issue of the case, the sentencing issue, for the remaining 5 minutes. Mr. Crowell is a septuagenarian brain-damaged prisoner who has been incarcerated for nearly all of his adult life since 1962, when he was a teenager convicted of second-degree murder under the felony murder doctrine after 3 older men recruited him to be their getaway driver for a robbery that resulted in a homicide. In 1987, after the governor commuted Mr. Crowell's sentence from life to 36 years to life, and Mr. Crowell was granted parole, Mr. Crowell was attacked and suffered a traumatic brain injury, rendering him severely and permanently mentally disabled. It was maladaptive behavioral manifestations of his injury that led to him being reincarcerated in 1990 until today. The men who actually committed the 1960s murder have been free for years, while Mr. Crowell remains in prison. The crux of the issues before you today is that the lower court should not have granted the defendant parole board a motion to dismiss under Rule 12b-6. The judge's decision suffers from both procedural and substantive fatal errors. The procedural errors stem from the statutory purposes of judicial review of administrative agency action under Standing Order 1-96, including writs of certiorari, and the substantive errors speak to the rights of disabled individuals under both state law and the Americans with Disabilities Act. The first issue presented before you is that
I'm going to stop you for a second. I don't want to ruin your rhythm. No, let's assume you're right. Let's assume, what is a parole board supposed to do if it is to take into account the disability of a person like Mr. Crowell?
Of course. So to survive a motion to dismiss, we just have to show that Mr. Crowell stated a claim upon which relief can be granted, which he did. And we showed that the parole board violated the ADA by discriminating based on conduct caused by his disability and without considering whether there are reasonable accommodations available to him. The actual reasonable accommodations we can leave to the discretion of the parole board because they have more expertise on deciding what the reasonable accommodations could be and have more resources than a volunteer law student organization or the brain damaged prisoner himself. At the very least, we would argue that they should have evaluated him and provided a full assessment as to the extent of his injuries and the role that those injuries played in his maladaptive behavior.
Is that something that the parole board is supposed to do? Is that part of their job, to test people and figure out what their problems are?
Well, we argue that under Title II of the ADA, yes, they are required to provide a full assessment of his injuries because the ADA actually requires that any qualified individual with or without reasonable accommodations should have the same access to public benefits that a non-disabled person would.
But is this a public benefit of the same type? I understand what that means. If a government agency provides a service, they can't discriminate against somebody because of their disability. But is this the kind of service that the cases are talking about?
Yes, Your Honor, it absolutely is. The Thompson case, the Ninth Circuit case, actually found that the Americans with Disabilities Act does apply to parole hearings. In that case, a mentally disabled prisoner was denied parole, and the Thompson court found that that was unconstitutional. It was a violation of the Americans with Disabilities Act.
But I had thought that opinion was premised on the parole board saying, I am denying you parole because you have a disability.
Absolutely. Well, that case, the Thompson case, in conjunction with the Yeski case and the Shedlock case, the decision of this court, the parole board is also required to provide reasonable accommodations. So, should that be required?
But we're trying to figure out what that means in practice. I mean, the parole board is evaluating whether a person poses, I forget the precise language, but essentially a reasonable likelihood of not posing a danger to the community. I assume that still is the test here, correct?
Yes.
So what does it mean to say they must consider reasonable accommodations?
Certainly. Well, we would contend that Mr. Crowell is not a danger to the community, especially because there's nothing in the record to prove that he is difficult to manage in prison, and there's no evidence that he would be difficult to manage on parole if he was provided reasonable accommodations.
Well, he violated parole every time he got it, didn't he?
Without reasonable accommodations.
But some of that was before he had his brain injury.
Right. Well, Your Honor, I would contend that someone is very different in their 40s than they would be in their 70s, and that him being consistently denied parole after his brain injury on a motion to dismiss standard, all of the maladaptive behavior he exhibited after his traumatic brain injury should be seen in the light most favorable to the plaintiff, which would mean that all of these behaviors are symptomatic of the traumatic brain injury.
Was that the reason why they denied him, because of his disability? I mean, wouldn't you have to allege and prove that ultimately that the reason for the denial was the disability?
Of course. Well, the parole board, a member of the parole board, if you could see the transcript attached at page 14 of the record appendix, a member of the parole board consistently repeated that his disability was a primary consideration.
She did. There's no doubt one member of the parole board kept on mentioning that because of the brain injury, that he would be difficult to manage. There's no doubt about that. But I believe Judge Asarian, in his decision, mentioned many of the reasons why parole was denied, and it was backed up by the record. As Justice Hines referred to, there's lengthy parole violations, there's substance abuse while on parole before the brain injury, and substance abuse was part of the issue involving the underlying crime that led to the shooting of the pharmacist. Being uncooperative on parole every time that he was released, not seeking rehabilitation, and I won't go through many other factors. I won't go through all of them, but one member of the parole board undoubtedly did refer to the difficulty to manage based on the traumatic brain injury. That is true. Is that enough in and of itself such that the motion to dismiss should have been denied?
Yes, Your Honor. Discriminating against someone for behaviors that are symptomatic of their disability is the functional equivalent of discriminating against someone for that disability.
Even if it's only one of many factors that go into a parole decision?
Yes. The Mintz-Levin decision of this court over the summer elucidates the fact that even if there is one discriminatory reason, that taints the entire decision. And in the parole board's decision, they discuss how he would benefit from an evaluation as to the extent of his injuries and the role they play in his behavior, but they never actually ordered that evaluation. Mm-hmm. So even though my predecessor at the Prison Legal Assistance Project provided the statewide head injury program as an option for a reasonable accommodation for Mr. Crowell upon parole, the board never even considered that. And they never explored the options available to Mr. Crowell to make him more manageable on parole, to keep this behavior within control. And so they're functionally warehousing disabled individuals and running out the clock until they die because of the reason that they're disabled.
Is it the role of the court to, even under the ADA protections, to tell the parole board how it's supposed to prepare to make its decisions, or how it is to make its decisions about who gets parole?
Yes, the parole board absolutely has discretion as to who and how it grants to whom and how it grants parole. However, it is still subject to the limitations of the Americans with Disabilities Act and state law that provide that with reasonable accommodations, disabled individuals should be given the same consideration as non-disabled individuals.
So if you win at trial, what happens?
Hopefully, assuming that the 12b6 order is reversed, Mr. Crowell would have the ability to present his case at trial, and that you and the trial court would provide guidance to the parole board, who would then give him a full and fair hearing, taking into account his disabilities and seeing if there is any way that they can help him be successful on parole, as opposed to just letting him die in prison because he's disabled.
So the consequence of your prevailing would be a remand to the parole board with instructions with regard to disability.
Yes.
All right, thank you.
Thank you.
Mr. Fitzpatrick, good morning.
Thank you, Mr. Chief Justice, and thank you, members of the court. My time is brief, and so what I would like to do, with the assistance of my reading glasses, is bring to the court's attention 2 points that were not raised in our brief, but have been brought to my attention, or I've uncovered since. The first point is a mathematical anomaly that has gone unexplained in this case throughout its history. The mathematical anomaly is one of sentencing, and anyone with criminal prosecution or defense background is familiar with this. There are 2 statutes that are implicated on this particular issue. One is Chapter 127, Section 133, and then there's the cognate statute, Section 133A, also of Chapter 127. Now, an oddity about this case is that in 1965, Section 133, and I'll refer to them in that shorthand, in that fashion, Section 133, Section 133A. Section 133, which essentially governs parole eligibility for all crimes except for life. And that's what is significant, of course, in this case, on this particular issue. And in 1965, the statute was dramatically changed and allowed for what then became known to criminal prosecution and defense practitioners as the 1/3, 2/3 rule, which was then repealed by the legislature in 1994 in the current form of Chapter 127, Section 133. And during that period of time, the 1/3, 2/3 rule was such that other than certain categories of crimes, generally speaking, crimes that were crimes of violence or crimes that one would find under Chapter 265 of our criminal code would be 2/3 crimes. And these categories of crimes were enumerated and defined in Section 133 as it was revised in 1965. And then there were the so-called 1/3 crimes. And the 1/3 crimes generally tended to be crimes one would find, for example, in Chapter 266, which generally covers property crimes and such, and crimes against various forms of property. The oddity in this case was, of course, stems from Governor Sargent's commutation in 1974. And the commutation changed the sentence of Mr. Crowell, who had been, as you heard from Ms. Cohen, sentenced as a teenager. Basically, he was recruited by these older men to be the getaway driver.
I'm sorry, you say a teenager. How old was he at the time of the crime?
This is the challenge of having a brain-damaged client and someone who is the proverbial equivalent of the man in the iron mask, who's been in prison for over 50 years now. The record is unclear, either 17 or 19, depending on what portion of the record one...
So he might be within Diachenko.
So it's quite possible, Your Honor, but I can't put a finger on that. This record is incredibly fuzzy through really no one's fault, but by dint of the age of this case and the age of this prisoner and how he has been basically warehoused, essentially without interruption since the early 90s in the state prison sentence. There was one brief attempt at parole about a little less than 20 years ago, and that did not work out. Within weeks, he was back in prison.
Okay, but you were saying it changed from life to 36 years to life.
Correct, Your Honor.
And so I assume you're about to say that it's a little bit screwy that he got the 1/3 eligibility for parole.
Yeah, exactly, Your Honor. So I would like to say great minds think alike, but I'm not the Chief Justice, so I'm not going to say
And I'm
that.
not a great
So
mind,
there
so
we go.
there we're even.
So in any event, and that I think goes to, what's significant there is it goes to the executive's intent in exercising the executive's basically free power to pardon or to commute. And it's a power that is invested in the executive in our Constitution and is fundamental to our ordered system of justice.
So he could have commuted it to 12 years and a day.
He could have commuted it to anything, Your Honor.
Back in 2003, Judge Crowell, who used to be on the parole board, issued a decision that said this is a life sentence. And I think his reasoning was it says life sentence.
Your Honor, I just want to clarify. Every one of Mr. Crowell's prior failed pro se efforts were premised on the fallacy, which we acknowledge is a fallacy. I mean, we're talking about a brain-damaged septuagenarian here, on the fallacy that he wanted to get out of prison. In his request to every court and every judge, as enumerated by the parole board, was simply, please let me out of prison. And yes, Judge Cratsley was absolutely correct in telling Mr. Crowell, you can't be let out of prison. You misunderstand what's going on. I would submit that what was not integral to Judge Cratsley's decision, but was parenthetical or dicta, if you will, was, oh, and you're serving a life sentence. Was this issue squarely presented and briefed to Judge Cratsley, as it has been to the trial court or to this court with the assistance of counsel? Of course not. So I don't think, I understand the parole board urges that to be an apt analogy. It is not. It is certainly not the law of the case, I would submit. The other point, the second point, and then I'm done, is simply an example of where an agency is not entitled, yet another of the many examples covered in our briefing, where an agency is not entitled to judicial deference in terms of how it construes its regulations or how it construes a particular rule, is the Connery case cited in our main brief. What I did not further describe with respect to the Connery case, C-O-N-N-E-R-Y, was that is an example of another rule of law, which is where an agency's interpretation of its own rules, regulations, and practices is inconsistent, such was clearly the case here, such as plainly the case here, then certainly that agency's interpretation of whatever is at issue is not due any judicial deference. And that's all.
Can you help me out with your mathematical anomaly? Are you saying that he served the sentence?
I'm sorry, Your Honor.
Are you saying that he served his sentence?
No, Your Honor. Based on
because we're still at parole eligibility.
It's parole eligibility. That's what we're talking about. Exactly.
Denied parole, you say improperly, right? So where does the Judge Cratsley error get you?
Oh, I'm not sure. Well, first of all, let's
Tell
take
me
a
there was
step
an
back,
error.
Your Honor.
Right.
Take a step back. I hope the court did not hear me to say Mr. Crowell should be denied parole and was properly denied parole in the past. That's not at all what I'm arguing. I'm simply saying Judge Cratsley, in answering Mr. Crowell's plaint back in the day, was correct in saying, no, you're not entitled just to be released. I mean, and nor do we take any position that even comes close to suggesting the parole board should be ordered to release Mr. Crowell.
Right, I'm
That's
just
not
trying
the
to.
issue.
I'm just trying to figure out where that gets you.
I gather what you're saying is that that the governor changed it to a term of years sentence, because if it were truly a life sentence, he would not be eligible for parole until after 20 years. But the governor made him eligible for parole after 13 years by changing it to a term of year sentence of 36 to life, that was the consequence of what the governor did.
Exactly, and most pivotally, Your Honor, in terms of statutory construction and also construing the intent of Governor Sargent, was that was done in the backdrop of the Attorney General's 1963 opinion.
Okay, and that means that he'd be eligible for parole next year, as opposed to
in 5 years. And that it was a term of, going to Your Honor's point, that was a term of years. It was the governor's intent that this man be given a term of years.
Going to Governor, not yet Governor Graziano, Justice Graziano's point.
Congratulations, Governor
well,
Graziano.
I haven't told the governor yet that the consequence of this is simply when he gets a new hearing.
Well, yes, and look, I understand
if you were not
why,
to prevail on the disability point.
Right.
I totally understand why the parole board finds it very annoying to have the proverbial man with the iron mask hauled in front of it every year, especially with the complexity of the universe of issues this man has. And they'd rather just see him every 5 years, frankly, to be blunt, until he dies in prison. And I totally understand that convenience factor. But that is not the charge of the state parole board. It is not their fundamental mission.
That issue's not before us as far as,
Correct.
right.
Yes, Your Honor.
That's what I was trying to get at.
Yes, I understand, Your Honor.
Great. And I appreciate the nomination, Chief Justice Gaines.
Yeah.
Thank you, and I second it. Yes, but thank you, and I'm sorry to run over my time.
Okay,
Thank you
thank
again.
you. Mr. Bloom?
Good morning, Your Honor. May it please the Court, Assistant Attorney General Todd Bloom for the Massachusetts Parole Board. This Court should affirm the allowance of the Board's motion to dismiss, as well as the denial of the plaintiff's motion for reconsideration. Your Honors, this is a case where the plaintiff has not adequately alleged that he is an otherwise qualified individual under the ADA, or that the Board unlawfully discriminated against him based on his disability. The Board agrees that it is subject to the ADA, that Mr. Crowell is disabled, and that he raised this disability with the Board. However, the ADA does not alter the standard by which parole is granted, and here the record shows that the Board reached its conclusion based upon an individualized assessment of parole. The Board acknowledged in its decision that his situation might be aided by an evaluation of the possible mental deficits associated with his head injury, but it also took into account his reasonable accommodation request, which was the parole to the Charlestown Recovery House, and that he received support from the SHIP program. Charlene Bonner stated in the transcript that living at the Charleston Recovery House would not be that much different than any other programs you have not been able to be managed in, and that there was no chance for improvement based on the expert opinions from the people at the Spalding Rehabilitation Hospital or those that she read, which were included in the parole packet. So the Board concluded that even with Mr. Crowell's proposed recommended accommodation, your release is not consistent with the welfare of society, Mr. Crowell, and you are denied parole. They took his accommodation into consideration. They gave him an individualized assessment tailored to him and counsel. They asked him specific questions. They asked counsel, what does the SHIP program entail? They said, suppose we give you the SHIP program and you complete it, what then? They asked the next step questions, and Mr. Crowell was not able to come up with a concrete plan.
I'm a little bit confused when you say he's not an otherwise qualified individual. Is it your position that if the parole board had said, because he has had a traumatic brain injury, that by itself is sufficient for us to deny him parole? Would you say that they would have a claim then?
No, Your Honor. We're saying that where you have a disability-related behavior, where you do here, and you have a propensity to commit the crime, where that head injury contributes to a propensity to commit the crime, that the board must make an individualized assessment, which they did, and consider a reasonable accommodation, which they did, in applying the parole standard.
But I think you agree that they may not use disability as a proxy for dangerousness. They could not say he is not, because he has traumatic brain injury, that by itself means that we're going to deny him parole. They would have to make some independent finding of the extent to which that would bear on his risk of recidivism.
Yes, sure. But they are not barred from considering that injury as part of his individualized inquiry. And where his disability contributes to his propensity to commit a crime, it is relevant in considering whether he is qualified for parole. And here the decision also shows they considered, in addition to his mental health, his lengthy history of parole violations, his returns to custody, his substance abuse while he was on parole, his program failures, new crimes on parole, and an uncooperative attitude. And I would submit that they based their decision on this uncooperative attitude. Considering poor behavior is not a categorical denial based on a disability. So they did all that was required of them, and to the extent Mr. Crowell is claiming that all of my poor behavior resulted from my head injury, the record shows that he was re-paroled in 2003, and he had a head injury in '87, which was well after his head injury. So the board factored in this disability, which was permissible. It was one consideration in their decision, which they were allowed to do. It was not the sole basis for their decision, and that was not the basis for their decision.
But that's not usually the finding you make for a motion to dismiss, which is viewing the pleadings in the light most favorable to the plaintiff, have they stated a claim? It sounds like what you're saying is that the judge, based on the partial transcript, essentially made a judgment on the pleadings, essentially.
Well, Your Honor, the judge took into consideration the claims raised in the complaint, which included a parole, the parole improperly denied me parole, the ADA claim, as well as the claim. It considered all the claims in the context of the motion to dismiss standard.
But he had a partial transcript as part of what he was reviewing.
Right, and the judge took that into consideration.
And I guess the question I have is just a little bit concerned about this being done. I don't quite know what the virtue was of a motion to dismiss as opposed to simply saying, here's the transcript of the parole hearing, and now we win, as opposed to we're going to move to dismiss because they have failed to state a claim. It seems they have stated a claim. They may not prevail on the merits of the claim, but why have they not stated a claim?
Well, Your Honor, I would submit that to state a claim.
Because would you agree that the Twombly standard should not apply because under Swerkowitz versus Surima?
No, Your Honor, I do not agree with that. The Swerkowitz case dealt with said that there was no heightened pleading standard for employment discrimination suits. It did not relieve parties from the standard, the pleading standard under Rule 8A2, and from the basic pleading standard. So I would submit that Ian Keno is the standard.
Okay, I mean,
Well, I guess when we're dealing with an abuse of discretion, which is what we're talking about by an administrative agency, would you concede that it's difficult to make that at the 12B6 stage, that finding?
Your Honor,
versus regular cert or 30A review?
I'm sorry, can you repeat that, Your Honor?
Sure. Superior Court judges every day make administrative reviews on a 30A or certiorari, correct?
Correct.
And normally, or in the usual course, it's done after reading the administrative record. And I think what the question we have and what Chief Justice Gantz was asking you, should we be concerned that this was done at the 12B6 stage when the complaint should be credited?
No, Your Honor. I mean, the Mass Appeals Court has said that dismissal under Rule 12B6 is permissible under paragraph 3 of the standing order. And a claim should not be dismissed unless it is shown beyond a doubt that no provable set of facts would entitle the plaintiff to relief. And I would submit that that is what the judge found here.
So you went through...
But he found it based in part on the transcript of the hearing.
Which was attached to the complaint.
Right, but I mean, he essentially made a factual finding that I don't think that this standard of abuse of discretion can be met here, as opposed to they failed to provide adequate specificity to what they're alleging.
Your Honor, I believe the motion judge said that at this stage, the court does not address whether the board's decision rested on substantial evidence, was arbitrary, capricious, or made errors of law. It just asked whether the complaint in the attachments plausibly state a claim, and the judge found that they did not.
But he said, I believe, that this head injury, traumatic brain injury, was one of many factors which went into the decision. And some of these other factors may or may not be related to the traumatic brain injury. And so the question is not at this moment, well, should he be paroled or should he not be paroled, but rather your position that disability was raised and considered and that was a proposed accommodation, it was considered, the SHIP program wasn't correct, whether or not all of that is an analysis that should be done at a motion to dismiss or in a judgment on the pleading.
Your Honor, there are cases that say the appropriate pleading is a judgment on the pleadings, but that a motion to dismiss is appropriate under the standing order, under Section 3. And also, the notes to Rule 12 say that a 12B6 must be made before serving any responsive pleading.
Put the 191-96.
Yes, Your Honor.
Put the standing order completely aside and assume that it's every right to have move to dismiss the case. The question is, under the standard, whether or not that motion to dismiss should have been allowed, or the Superior Court judge should have said, file the administrative record and I'll decide this on a 30A.
Your Honor, I would submit that that you do not have to submit an administrative record because the complaint and the attachment, which the plaintiff chose to put in, show everything that I am claiming, and a record development will not change that. All of the claims were analyzed under the 12b-6 because they were made part of the complaint.
Okay, turning to the life sentence issue, why is Mr.
Yes, Your Honor.
Fitzpatrick not right that Governor Sargent turned what was a pure life sentence, which as a life sentence would have made him eligible for parole in 20 years, which would have been, I guess, 1982, and instead, based perhaps on some mistaken understanding of the 1/3, 2/3, meant that he got a parole hearing in 1975.
Yes, Your Honor. Mr. Crowell was statutorily eligible. He pled in 62. He normally would have been eligible in 77 under the 15 years. However, in 1965, the statute was amended to change from 20 to 15 years in 1965. It was made retroactive to people like Mr. Crowell, who pled guilty before.
But he still got a parole hearing earlier than he otherwise would have if the governor had not done what he did.
The governor commuted it from life to a term of 36 years to life, creating parole eligibility in 12 months or December 23rd, 1975. The record does not give the basis for those sentencing commutations. I do not know the basis for those specific dates.
I mean, whatever the reason, the governor doesn't need to give a reason. The governor can just do it. And he did. So are you saying there's no consequence?
No, I'm saying the governor's change impacted the initial parole eligibility date only. And the remainder of the sentence and the conviction did not change. Nothing changed except the initial parole eligibility date. It was advanced, if you will, or altered from 1977 to 1974. Now, he was released on parole in 1975, which oddly enough is after he would have been parole eligible in 74 and before the date of December 23rd, 1975. But again, I do not know the basis for those dates. So but the governor would not have had the authority, I don't know much about commutation, but I don't think the governor would have had the authority to say, this is still a life sentence, but I direct the parole board to give him a parole hearing in 1974 before he otherwise be eligible according to the statute. He had to commute in order to accomplish that. Yes, the commutation under this court's case in Hicks, which I would say is instructive on this point. There is no indication in the record that he intended to pardon Mr. Crowell or lessen the offense. The commutation changed.
Right, well, I get the question really is, I gather, you agree that if this is a term of year sentence, he gets a parole hearing next year, or whatever, or a year after he last got a parole hearing. Isn't that true?
If it is a term of year sentence, which it is not.
Okay, but if it is, then he gets it next year as opposed to in 5 years.
Correct.
And so the issue is, did Governor Sargent effectively, by doing what he did, change a life sentence to a term of year sentence, with the term being 36 to life?
He did not, Your Honor. Parole eligibility is determined by Chapter 127, Section 133. 133A deals with life sentences. In general, a prisoner sentenced to state prison is ineligible for parole until he has served the minimum term of the sentence.
But that makes Mr. Crowell's point. What you just said makes Mr. Crowell's point, that there's nothing the governor could do about it. The parole eligibility was, after the change in 1965, was 15 years. He couldn't change the statute. He could commute the sentence.
He commuted the sentence, which advanced.
Can't change this, but just as you were just saying, you're absolutely correct. He could change the sentence, but he couldn't change the parole eligibility. He couldn't change the statute.
That was the practical effect of the commutation, was to advance the parole eligibility date, considering what the statute was at the time.
But do you understand what Mr. Crowell is saying is since you couldn't change the parole eligibility date, whether it was a Scrivener's error or whatever, that meant that the governor changed the sentence. I'm not saying they're right, but that's their argument. And so when you read from the statute as to what the parole eligibility is, that's just augmenting their argument.
Your Honor, the commutation, murder was a 1/3 crime at the time. So when the governor changed it to 36 years to life, he advanced the parole eligibility date from 77 to 74. He advanced that date to make him parole eligible as of that date, but nothing else in the conviction or sentence was changed. The rest of it remained under Section 133A, is what we're saying.
Okay, thank you.
Thank you, Your Honor.